to be the person whose case ends up in the law school course.
Don't just pay that ticket. Go to attackthatticket.com or call today, 877-99-NO-TICKS.
Hey there, YouTube fans. It's Mike Palumbo, and I got a case here that I just found from the New York State Court of Appeals. Just issued a decision on April 1st of this year regarding discovery and disclosure and supporting depositions in criminal cases. And the New York State Court of Appeals is the top court of the state of New York. So the way it goes is you have your Supreme Court, which is really your county court. We call it Supreme Court. There's a Supreme Court in the county. And there's 62 counties, 62 Supreme Courts. And after your case is done in a Supreme Court, or in this case, in a court inferior to it in the county, this case come out of the Suffolk County Traffic Violations Agency, you have a right to an appeal. And there's 6 appellate courts in the state of New York. So once your case is done in a lower court, you have a right to an appeal, which is what happened in this case. And after that appeal, whoever lost that appeal could request a review to the top court of the state of New York, which is the New York State Court of Appeals. You don't have a right to it, but you could request it, and if they feel it's an important enough issue, they're gonna tackle it. They're gonna take it on and make a ruling. And that's what happened in this case. It all started when the defendant, her name is Daria Epakchi, so it's the people versus Epakchi, ran a stop sign in Suffolk County, and she got a ticket returnable to the Suffolk County Traffic Violations Agency. And what's apparent to me from reading all the papers, and I actually even found the appellate arguments online. I'm going to link the decision and the appellate arguments to the New York State Court of Appeals in the description below, so you could, if you want to peruse it yourself. It's very interesting, though, watching the oral arguments. But it's apparent from the very beginning that she had an attorney. And so what she did, she and her attorney did, was they demanded a supporting deposition. Now, supporting deposition is one element of discovery and disclosure you're entitled to under criminal procedure law when you get a traffic ticket. And it's kind of almost like the main one that everyone's going to demand, minimally a supporting deposition. You're entitled to other stuff that's more technical. You got to really read the criminal procedure law. There's a lot of, you're entitled to, calibration instruments, proof of calibration of instruments used, statements made by the police officer. You're entitled to a lot of stuff. But the basic one is supporting deposition. And basically what it is, it's just a further report. It's just a further report of what happened. So the ticket is called the UTT, Uniform Traffic Ticket. It's also known as a complaint. And it just basically is date, time, location of the incident and what the cop alleged you did wrong. The supporting deposition fills in the gaps. It gives a report of the specifics of what you did, so you could better defend yourself and better prepare your case. And they demanded it. The prosecution has a certain amount of time to serve it. And in this case, it seems like it was served on time, but it was facially insufficient. And what I mean by that is they have to state enough facts and evidence as to what happened, so that if all those facts in there are believed, you're guilty. So they have to state what we call a prima facie case. The attorney moved the court, dismissed the case because the supporting deposition lacked sufficient specificity. It didn't state a prima facie case. And that motion, initial motion, was granted. But what happened was, and I want you to make a mental note of this, the judge then told the prosecutor to perfect. In other words, they dismissed it, and the judge in open court, because this is in the papers, directed the prosecutor to re-serve the ticket with the proper forms, with everything perfected correctly. And I just want you to make a mental note of that. The judge told the prosecutor to do something, to basically refile the case. Now, can you do that under the criminal procedure law? Yes. If the case gets dismissed for failing to serve a supporting deposition, basically converting the complaint to a prima facie case, the prosecutor can refile the charges as long as not enough time has gone by. which hadn't. And this is also true of misdemeanors. So what we're talking about here also applies in a more serious case, an assault case, a DWI case, a larceny case. So they refiled it, and they refiled it, and then the attorney made another motion to dismiss, saying, look, you can't do that. And I just said you can do that. But the lawyer wasn't really wrong. And here's why. Because we have, like I said, we have three levels of courts. The court, the county courts, the local courts, the Supreme Court. Then you got the appellate courts, which are called appellate divisions or appellate terms. And then you got the New York State Court of Appeals, which is the highest court in the state. They're not set up like other court systems. The intermediate appellate courts, the appellate terms, and the appellate divisions aren't true appellate courts. This is in the CPLR, the Civil Practice Laws and Rules. They're actually, and in the judiciary law, they're actually Supreme Courts. And like I said, the Supreme Court is the top court in the county. So they're actually on a Supreme Court level. So, and again, a Supreme Court is a trial court. And the Supreme Court, all trial courts are inherently courts in equity. In other words, they have inherent equitable powers to do what's right beyond just the books. So because the appellate courts are part of the Supreme Court system and aren't pure appellate courts, they have certain statutory and common law rights to review facts and reject an established fact, or to make their own findings of fact. It's sort of in a limited way. And this is based on statutory law, and this is based on common law. And it's based on the way the New York State those intermediate appellate courts, what level they're actually on. So in the particular appellate court that you would take an appeal to here, they've carved out a rule against a general statute. And they said, listen, in a case of a traffic ticket, when it's dismissed for no supporting deposition or insufficient supporting deposition, you cannot refile charges, but for extenuating circumstances. So when they refiled the charges, there were no extenuating circumstances. It's just, they wanted to refile it. They did it wrong the first time. That's not an extenuating circumstance. And now this particular carve-out was only in this one. There's 6 appellate courts, but only this one has this carve-out. So the defendant's attorney moved again to dismiss. Now remember, I told you the court told the prosecutor to reindict. So what do you think? They denied that motion. Like, yeah, you know what? That's wrong law. Okay. Now, what was on the prosecutor's side? I don't want to say what's on the court side, because we're going to talk about the court. We're going to get to that, because they did something very wrong. But what's on the prosecutor's side is, back in 1991, there was an appellate court case, the New York State Court of Appeals case, went all the way up on a misdemeanor about this very issue of reindicting after a dismissal for basically a procedural dismissal because you didn't perfect, you didn't convert your complaint to an information, is what we call it. You perfect, and then there's no jurisdiction. And this is exactly what happened. They reindicted, and the defendant in that case said, no, you can't do it. And because the CPL, the current procedure laws, allow you to do it, but it's just silent as to whether or not you can do it. But there's other law about statute of limitations and speedy trial that wasn't being violated. New York State Court of Appeals said, no, as long as they're not violating speedy trial or statute of limitations, or double jeopardy hasn't attached, which it hasn't at that point, they can refile, right? So there's a Court of Appeals decision that says they can refile. But this particular appellate court, which is inferior, of course, to the New York State Court of Appeals, basically made a carve-out. And their carve-out wasn't like, well, we're going to thumb our nose at what the New York State Court of Appeals says. The carve-out was like, hey, we have the power to make rules and decisions that are inherently equitable under the authority we have under common law and under statutory law. But the basic premise that they can reindict, there was good New York State Court of Appeals decision on it. So At the trial level, the second motion gets denied. She takes her case to trial, and what do you think's going to happen? When the judge says reindict this case, no joke, they find her guilty. And then the defendant took the appeal to the appellate term and said, look, there was no special circumstance. This is the rule in this jurisdiction. Apply the rule. And the appellate term did. They said, you know what? Yeah. The second motion should have been granted, and so we're granting that motion and we're vacating the conviction. The state, the county attorney in Suffolk County, requested leave for review to the New York State Court of Appeals, the top court, and they accepted it. And just the other day, they sided with the prosecution. They said, you know what? That appellate term has it wrong. They're overstepping. This is extrajudicial. This is extra statutory. While we recognize you have, certain other rights, the way our laws are set up, this is inconsistent with the statute. This is inconsistent with case law. And so what they did was they reversed it. So now, but wait, there's more. The case isn't over yet. They didn't reverse the appellate term and then reinstate the conviction and end it. They said, well, there were other issues on appeal that the appellate court didn't reach, which potentially could also have led to a dismissal. So we're remanding it back down to the appellate term to make another decision. So this case is still going on, right? And the reason why I'm kind of laughing is because I told you she got pulled off running a stop sign. That happened in 2013. It's been 8 years. 8 years. And this is the cautionary tale. I can guarantee without even knowing that she probably was offered a parking ticket for a few $100 fine. And I give her credit. I respect what she's doing. She feels that she's not guilty, so she didn't want to take any deal. That's probably, I don't know her. I never spoke to her, haven't spoke to her lawyer. But I'm in that court all the time. I'm in these other courts all the time. And this is what I always tell people. Look, I could have got your case dismissed. True. Okay? But if I take a parking ticket for you and you pay a $125 fine, it's a final adjudication on the merits. It cannot come back in any way to haunt you. If I get a case dismissed and double jeopardy is not attached, or statute of limitations hasn't run, which is a 1-year statute of limitations, and it's too early, they can reindict. As a matter of fact, the statute of limitations have run. There's nothing stopping them from also reindicting. Or if jeopardy has attached, there's nothing stopping them. Then you got to fight that again. Yes, you will win, but it can cost you a lot of time and money. So if I close it, if I get leverage to get a case dismissed, and I do this all the time, I get good leverage to get a case dismissed, I'll say, look, rather than dismissing it, why don't we just close it out on a parking ticket? I'll withdraw my motion, or I won't make my motion. And it's the better option, because this is what can happen, and this is often what happens when you push a dismissal without at least offering an olive branch. Say, hey, look, have my client pay a fine, and it'll be over with. Now, it's going back to the appellate term for more litigation, which I'm guaranteed costs this woman a fortune. I feel bad for her, but I respect her. Okay, it goes back to the appellate term. Why? Well, remember I said make a mental note. The judge told the prosecutor what to do. That's illegal. Not illegal like you're going to go to jail illegal, but that violates. Look, the judge is the umpire. He calls the balls and strikes. That's like him telling the pitcher to throw a fastball. What do you think's going to happen when the pitcher throws the fastball? It's going to call a strike. It violates your due process rights to have a judge supervise the case to that degree. When he's ordering the prosecutor around, helping the prosecutor, it would violate the state's due process right if they help the defendant. They're not there to help either side. Now, deciding to reindict and prosecuting a case is an executive and not a judicial function. It violates the Separations of Powers Act under the New York State Constitution, and it violates the due process rights under New York State as well as the federal Constitution. Maybe the prosecutor didn't want to reindict. He just didn't care. He's in that court all the time. The judge tells him, hey, reindict this person. What's he going to do? He wants to go along to get along. He's going to do it. It's not the judge's prerogative to direct a party. one way or another. And judges have been removed from the bench from actually helping defendants, telling defendants and defense counsel what to do. That, hey, if you do this, I'm probably going to dismiss the case. That's improper too, even though it can help, the individual. Not right. Another problem is that the prosecutor said on his oral arguments, well, I served the ticket with the supporting deposition the second time around, so it was perfected. Well, that's wrong too. A prosecutor can serve a complaint. A traffic ticket is really called a complaint. Prosecutors can serve that, or the prosecutor himself, prosecutor's investigator, that can be served. Doesn't have to be given by the cop, but the supporting deposition under statutory law, and that's really what the Court of Appeals applied, was direct statutory law. Says the police officer must serve the supporting deposition, the police officer or an employee of the police department. This is what the statute says. And within 30 days, they have to file an affidavit of service with the court. This all has to happen within 30 days of the demand. And if it's not served by a police officer or an employee of the police department, and if the affidavit of service isn't filed within 30 days, then it's tantamount to no service and leads to a dismissal. So this attorney admitted, hey, when I reindicted him, I served him the ticket with the supporting deposition, so there'd be no problems. Well, that creates a problem. That is, in and of itself, a huge problem, because the police officer has to serve it. So if you want to apply the statutes, as the Court of Appeals, properly did. I understand where the appellate term, that appellate court came from, and saying we have other authority. We're not really inconsistent with what the Court of Appeals said. I understand where they came from. And I also understand where the top court of the state of New York came from. So, but if you're going to apply that, you got to apply it then. All right. Secondly, there's an issue with separation of powers, due process, a judge ordering a prosecutor to prosecute. A prosecution is an executive function, and they could decide independently that they want to decline to prosecute further. That's their right every single time. And a judge can't usurp it. But by putting pressure on a prosecutor, he is usurping it, and he's improperly basically taking over making an executive decision. When I say an executive function, law enforcement and is in the executive branch of government, whereas the judiciary is not, and then you got your legislator. So it was improper. So I'm reading between the lines here because I'm a lawyer, and I want to see that. I would actually like to see the underlying papers. So what appellate courts often do, I am sure, because I saw the oral argument. I'm assuming that this attorney represented her below too, and did all the other work. The defense lawyer and by the way, the county's lawyer, they were both great lawyers. Okay, I'm sure he raised all these issues. Like, okay, this is your rule. Also, by the way, the judge did this. They served it wrong. The prosecutor had no right to. They probably put all these issues in it. And what appellate courts often do is they got a lot of cases to read. They're looking like they could just decide on this issue alone. And they probably wrote a decision that says something like, notwithstanding all the other things going on in this appeal, just based on this alone, we're granting a relief that's requested by the appellant. We're granting a motion and we're dismissing the case. Now all of a sudden, all those other issues become moot. That they didn't write a decision on. Well, if they didn't win here, they were going to win here. And if they didn't win there and they didn't win there, they were going to lose here. They're not going to go through that. They're going to say, hey, everything else is moot. Let's move on to the next one, right? So that's why it got remanded, because the appellate New York State Court of Appeals saw everything and they're like, well, seem to have other legitimate issues that they never reached. So now we're going to send it back down to them to say, hey, that decision was wrong. But you got to reach these other, because the New York State Court of Appeals isn't going to go through that. Well, we read everything too. They're going to remand it back to the court. Say, hey, if you have another ground, dismiss it. Make that decision. That's where it is. But we're talking about a stop sign in 2013, though. That's the overarching point of what I'm trying to say here, okay? The prudent thing to do, whether you think you did it or didn't do it, it doesn't matter. Get a good offer on the table, close it out so your insurance doesn't go up, your license doesn't get suspended, and move on with your life. Because again, I do respect this defendant, this woman, for fighting so hard. But I would love to like find her one day and interview her and maybe do a podcast with her or something. Because at the end of the day, I kind of think she's regretting it. Like, who would ever think that a simple issue like this would go to the New York State Court of Appeals? But this is what can happen. I tell people when I explain the law to them, like, well, there's a case, and I go, listen, you don't want to be the person who's a defendant in that case, because it's going to cost you a lot of money to so that people like me could be like nerding out over it for the next bunch of years and teaching. You don't want to be the person whose case ends up in the law school course, because whatever happened, you've lost, So anyhow, that's it for today. A very interesting point in law. Certainly went on for longer than I wanted to. I hope you enjoyed it. And, I'll make them shorter in the future. See you at the next one.